I'm Tulsa divorce attorney Palmer Johnson. Welcome to my video series where I address frequently asked questions about divorces, guardianships, and adoptions. Today's question is, I want to modify the child custody order from my divorce. Can I do that? The short answer to the question is yes, but you're going to have legal grounds to ask the court to modify your order, and it needs to be a permanent, substantial change in circumstances since the previous order was entered. And the standard is there so that people aren't just continuously litigating the same issue. In other words, let's say you get divorced and you have a trial and the court orders joint custody and 50-50 time. That's what they determined to be in the children's best interest. And 2 months later, you want to file a motion to modify. Well, that's probably going to be a non-starter because you can't use the motion to modify in substitution of the appeals process if your allegation is that the court got this wrong. But if a substantial amount of time has passed, at least 12 to 18 months, if there is a compelling reason or a change in circumstances that meets that standard, then you could ask the court to modify child custody. And typically, if you were filing a motion to modify, it would be because you had joint custody and you felt like you needed to have sole custody, or the other parent has sole custody and you want joint custody, or you want sole custody and you think there's some compelling reason why the court got it wrong and it would be in the children's best interest that you have sole custody. The overall standard, once you've established that you've met the burden for modifying the order, is still going to be the best interest of the child as far as how custody is determined. And sometimes, instead of modifying a child custody order, you might look at simply adding a tool that could help you operate better under your current order. For example, if you had joint custody and you had communication problems with the other parent from time to time, to the point that it was you wanted to do something about it, or you would kind of find yourself having sort of small disagreements with the other parent under a joint custody plan, but cumulatively they add up to a high level of frustration, and things where you get to kind of a stalemate. Perhaps a parenting coordinator would be a useful tool to help you navigate through those things. And also, if the other parent's kind of abusing the process, because you can have the court allow the parenting coordinator to allocate fees based on sort of if something's unnecessary, the other party's being unreasonable. It's a useful tool at that point to curtail and put a stop to some of that, because when people have to pay for it, it is not as much fun to just argue about things that seem fairly straightforward and apparent to any outsider that it should be done a certain way. So you can modify an order, and if you find yourself needing to modify a child custody order, you can find me on moms.law. If this video was helpful, please like or share, and I look forward to answering more of your family law questions in the future.